My name's Ollie, and in this Politics Explained video, I'm going to go through everything you need to know about the nature of the US Constitution in A-level politics. I'm going to start by looking at the parts of the specification this video covers, as well as key questions you could get asked on the Constitution in the exam. I'm then going to give an introduction to the US Constitution, looking at its creation as well as the key parts of the Constitution. I'm then going to look at the codification, entrenchment, and the amendment process, including advantages and disadvantages of the amendment process in particular. And then finally, I'm going to look at the blend of specificity and vagueness in the Constitution. The PDF you can see on your screen is part of an updated textbook in relation to the US side of the course, which you can find on the Politics Explained website, where you'll soon also be able to find US essay plans and 12 marker plans before this year's exams. And there are also loads of other resources to help you in your politics A-level, including essay plans, updated textbooks for the paper 1 and paper 2, as well as a place to sign up for tutoring if that's something you'd be interested in. But yeah, without further ado, let's get into it. So starting off in terms of the parts of the specification this lesson covers, so this is the very first part of the US Constitution topic, looking at the nature of the Constitution. So we're going to look at its vagueness, codification, and entrenchment, as well as the amendment process, including advantages and disadvantages of the formal process. In terms of some of the 12 markers and essay questions you could get in relation to this topic, all of these in bold effectively are for the whole of the Constitution topic, because it's effectively you need to take things from different videos and different parts of specification, as is often the case with these US essays. But the kind of ideas, ones that are particularly focused on this, so some of the 12 markers, so the difference between the sources of the US and the UK constitutions, overall similarities between the US and the UK constitutions. Also, in terms of some of the 30 markers that are really specific to this video, would be ones in relation to the entrenched and codified nature of the US Constitution has more advantages and disadvantages, and the extent to which the formal constitutional amendment process works effectively. But as I said, this will also help for lots of other questions, and lots of the other videos will also be really helpful to answer these questions as well. So yeah, starting off by looking at an introduction to the Constitution, and first looking at the creation and history of the US Constitution. So the drafting of the Constitution came out of the Constitutional Convention in Philadelphia in 1787, where delegates from the original 13 states or colonies came together to agree on how the United States should be governed. The Constitution took 4 months to write and was completed by the 17th of September 1787, and the key men who wrote the Constitution have become known as the Founding Fathers, including James Madison, George Washington, and Alexander Hamilton. You may have heard of those. 2 key compromises are worth noting in the drafting of the Constitution. The first was the Connecticut Compromise, and this was in relation to representation in Congress. And there's a key disagreement with states with small populations wanted equal representation per state. So for example, every state gets 50 representatives, for example, whereas states with larger populations wanted representation to be based on population. And the Connecticut Compromise agreed on the bicameral structure of the United States Congress, in which the Senate has equal representation per state. So currently there's 50 states, and every state gets 2 senators. And the House of Representatives has representation based on population. So for example, smaller states like Wyoming, for example, have much fewer, or Alaska kind of has 3 members of the House of Representatives, whereas California or Texas, these more populous states, have a lot more representatives. So I think California has at least 50 representatives in the House of Representatives. The next key compromise was the 3/5 compromise. So there was disagreement between states in the north and south about whether slaves should be counted as part of a state's population. Southern states had large numbers of slaves, so if they were counted as part of the state's population, they would have increased their representation in the House of Representatives, which is why they wanted them to count as part of the state's population. And ultimately they came to agreement, the 3/5 compromise, which settled on counting slaves as 3/5 of a person. And this remained as part of the Constitution until December 1865, so for nearly 100 years, when the 13th Amendment was introduced to abolish slavery. In terms of the different parts of the US Constitution, the first key part it's worth looking at, which you've probably heard of before, is the preamble. You can read it on your screen now, but it really immediately kind of shows the key principles of the US Constitution, what it was driven by, with liberalism being really key. So securing the blessings of liberty is mentioned, providing for common defence, promoting the general welfare. So the kind of real need for why they believe there's a need for a central state, but a real commitment to maintaining liberty. Next key part of the Constitution are the 7 articles, and effectively each article is in relation to a different part of the Constitution. Effectively sets out the key rules, how it should govern, etc. So the first one's on the legislative branch. So it sets out that legislative powers are held by Congress, consisting of the Senate and the House of Representatives, and it also sets out how those are elected, as well as the composition of both chambers, how lawmaking works, and the key powers of Congress. Second article looks at the executive branch, so sets out that executive power is held exclusively by the president, elected every 4 years, and can be removed through impeachment. Also sets out how they're elected and the powers of the president. Article 3 does something similar in relation to the judicial branch. Article 4 looks at the relationship between the states as well as the relationship between the states and the central government. Article 5 sets out the process for amending the Constitution, which we'll look at in a lot more detail later in the video. And then the final 2 articles, there's the kind of Article 6 looks at a number of various provisions, including the Supremacy Clause, which we'll look at, and Amendment 7 looks at the ratification procedure. So it kind of set out that 9 out of 13 colonies were required to agree in order for the Constitution to be originally ratified. Very soon after the Constitution was introduced, so less than 5 years afterwards, the Bill of Rights was introduced. So it's effectively a key part of the Constitution from almost at the start. But the Bill of Rights consists of the first 10 amendments to the Constitution. So there's been 27 amendments in total. 10 were introduced at one time in the Bill of Rights, just 4 years after the Constitution was passed. And you can look at all of them online, but I thought I'd just include some of the key amendments. So the First Amendment is in relation to freedom of speech, press, assembly, and petition. And it says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech, the press, the right of the people to peaceably assemble, and the petition the government for a redress of grievances. So really reflecting key classical liberal beliefs in terms of protecting key freedoms of individuals. The Second Amendment, which you will have heard of, is in relation to the right to bear arms. And the 10th Amendment, a very important amendment, pertains to which powers are held by the states compared to the central government, which we'll look at federalism, we'll look at how it's a key topic and has always been a key topic in US politics. And it effectively says that all powers not reserved to the central government, so either to Congress or to the presidency or to the judiciary in the Constitution, are reserved to the states. And they say that comes to the people as well. Then, since the Bill of Rights, there have been 17 amendments, so very, very few amendments. We'll look at the key reasons for that a little bit later. And even 2 of those, one was cancelling out the other. So the 18th Amendment prohibited, it was a Prohibition Amendment, prohibited the manufacture or sale of alcohol in the US, and the 21st Amendment revoked that. So in reality, just 15 operative amendments in over 230 years since the Constitution was introduced. There's a lot of them are really, really important. Vast majority of them are, but I thought I'd just highlight a few of them here. So, 13th Amendment abolished slavery. The 16th Amendment introduced income tax, which had been illegal under the Constitution before this amendment was introduced, and it was effectively judged that the US state, in order to provide for defence and effectively needed to facilitate more spending, and to do so, it needed an income tax. So the states and Congress came together to pass an amendment to allow it to do so. The 19th Amendment introduced the right to vote for women. The 22nd Amendment introduced presidential term limits, which says that a president can only be elected twice or only serve 2 terms, and this was particularly in response to FDR serving, I think it was 4 terms in the end. And then the most recent amendment, which I thought was worth including, is the 27th Amendment, passed in 1992, which says that no law varying the compensations for the services of senators and representatives, so varying their pay, shall take effect until an election of representatives has intervened. So effectively, they can't increase their own pay before another election. Okay, so that's the introduction to the US Constitution. What we're going to have a look at now is codification, entrenchment, and the amendment process. This is the key nature of the US Constitution. So first, having a look at how the US Constitution is codified. So the US Constitution is codified because, unlike the UK's Constitution, it's written down in a single document which sets out the structure and rules of the governance of the US. The individuals and institutions that govern the US derive their authority directly from this written constitution. And the supremacy clause, set out in Article 6 of the Constitution, sets out that the Constitution is higher law than any other legislation passed in the US, either by the federal government or by states. And as a result, other legislation can be struck down and unmade by the judiciary if it doesn't abide by the Constitution. So codification really embodies the fact that it's written down in one law. The US Constitution is entrenched because it's very difficult to change, with the amendment process requiring supermajorities and the consent of multiple parts of the US political system. This means that it's especially protected, and that there have been very few amendments to the Constitution since it was first introduced. As I said, 27 amendments, 2 of those cancel each other out, and 10 were introduced kind of almost straight away in the Bill of Rights. So in reality, only kind of 15 operative amendments. In terms of how the amendment process works then, so there's 2 ways that amendments can be proposed. The first is through a 2/3 vote, so it's a supermajority, in both houses of Congress. And the second is through a 2/3 vote in a national convention called by 2/3 of state legislatures. The latter's never been used, so it's effectively the first one. In terms of ratifications, that's how it gets proposed. And once that has happened, then it goes through to ratification, where it goes to the states. And there's 2 ways amendments can be ratified. The first is through a majority vote in 3/4 of state legislatures. And the second is through a majority vote in 3/4 of special state conventions. The former's been used successfully 26 times, the latter only once, to repeal the 18th Amendment. So it's a very, very difficult amendment process. You need supermajorities in both houses of Congress, which, especially in the current environment, is almost impossible to get on anything. And you also need 3/4 of states. And it's intentional. So the founding fathers recognised the need to amend the Constitution, but made it a very difficult process because they wanted to prevent reactive changes and to protect the key principles and provisions of the Constitution, which they thought was a very good document. And as I said, this has led to there being very few amendments. There hasn't been an amendment since 1992, and it doesn't look like there's going to be any agreement on one anytime soon, due to the kind of deeply partisan and divided nature of the US political system at the moment. In terms of some case studies of successful and failed amendments, first one we'll have a look at is the Income Tax Amendment. So in the 19th century, the majority of federal revenue came from tariffs rather than taxes. But in the latter half of the century, there was increasing opposition to tariffs on the basis that they unfairly taxed the poor. So the 1894 Wilson-Gorman Tariff Act sought to introduce an income tax in order to kind of tackle this, but it was struck down by the Supreme Court as unconstitutional, as direct taxes that didn't apportion their revenues among the states on the basis of population were unconstitutional in relation to the Constitution. And in response, the 16th Amendment was passed by Congress in 1909 and ratified by the states in 1913, allowing Congress to levy an income tax without apportioning it among the states on the basis of population. Second successful amendment is the 22nd Amendment, the second one we're going to have a look at is the 22nd Amendment. And prior to FDR, there was a 2-term tradition after Presidents George Washington and Thomas Jefferson decided not to serve a 3rd term, even though it's quite likely that they may have been re-elected. So it was kind of a tradition and a convention. This was the case, but FDR effectively broke it, winning a 3rd term in 1940 and a 4th term in 1944. And this led to real concerns about a president serving for an unlimited number of terms, because key to the US political system, the US political culture, and US Constitution is the idea of liberty and preventing tyranny from one individual. And Roosevelt talked at times about packing the court, and there were just general worries about a president having too much power. As a result, in 1947, the 22nd Amendment was introduced. It was approved by Congress and ratified by the required 36 out of 48 states in 1951, saying that a president can only serve for 2 terms. In terms of failed amendments, over 13,000 amendments have been proposed. The vast majority of these fail at the proposal stage, kind of failing to get 2/3 support from both houses of Congress, and never even advance to the states for ratification. But some do get proposed, but fail to be ratified. So one key amendment that failed is the Equal Rights Amendment. So the proposed Equal Rights Amendment would have guaranteed equal legal rights for all American citizens regardless of sex, and it was introduced first in December 1923, but reintroduced in 1971 with the rise of second wave feminism in the US. It was successfully proposed, so two-thirds majority in both houses of Congress in 1972, but it ultimately failed to gain the 38 state ratifications necessary for it to be passed, receiving just 35. 5 of these ratifications were later removed after a conservative movement led by Phyllis Schlafly mobilized against the amendment. And then there was renewed support after the Me Too movement in the 21st century, with 3 more states ratifying, but due to the 5 revocations, the amendment is still judged to have not been ratified and therefore hasn't been introduced. Another often proposed one that hasn't been passed is the Balanced Budget Amendment. So there's been numerous attempts to pass a proposed Balanced Budget Amendment, which would force the federal government to balance its budget in any given year, except for in exceptional circumstances such as war. And this has really been supported by Republicans in particular. The amendment has failed to receive two-thirds support from either the House of Representatives or the Senate in order to be passed, however. And then a key proposed amendment in the early 21st century, was the Flag Desecration Amendment, which aimed to give Congress the power to prohibit physical desecration of the American flag. And this largely stemmed from the Supreme Court's decision in Texas v. Johnson, which declared that flag burning was protected speech under the First Amendment. It was introduced multiple times and frequently passed the House of Representatives, but faced hurdles in the Senate. And its closest moment to realization was in 2006, when it fell just 1 vote short in the Senate. Okay, so that's the formal amendment process, and that's the only way that the actual text of the Constitution can change. It's arguably not the only way that how the Constitution is applied can be changed. Instead, there's also what can be called interpretive amendments through judicial review. And that's when, through judicial review, Supreme Court judges, and the Supreme Court as a whole, is able to change the interpretation of the Constitution. And when the interpretation of the Constitution is changed, that changes how it's applied. So, for example, if the Constitution said that the Congress has the power to create lots of ships, and earlier, like 100 years ago, the Supreme Court judged that as 100 ships. The Supreme Court could change and now judge that as 1,000 ships, right? And even if the text of the Constitution hasn't changed, it almost has been amended in terms of its implementation. So that's kind of what we mean by interpretive amendments. Obviously, that's a very, very simplistic example, and not really what we're talking about. But these interpretive amendments can be hugely consequential for US political life and the rights of US citizens. There's big disagreements about how to interpret the Constitution. So textualism argues that the Constitution should be interpreted very literally, so exactly what the Founding Fathers were saying. Originalism argues that the intentions of the Founding Fathers should be followed, so not just exactly what the text is saying, but trying to follow their intentions. And living constitutionalism argues that the interpretation of the Constitution should evolve with changing circumstances and values in society. When we look at the Supreme Court part of the course, we're going to look at these in a lot more detail, but effectively the first two are more likely to be supported by conservative justices, whilst the latter is more likely to be supported by liberal justices. A key example of interpretive amendments through judicial review is in relation to abortion. So the 1972 Roe v. Wade case legalized abortion across the United States using the 14th Amendment, a civil rights amendment that mandated equal protection under the law. But in the 2022 Dobbs versus Jackson Women's Health Organization case, the Supreme Court reversed the decision by changing their interpretation of the Constitution, changing their interpretation of the 14th Amendment in particular, which they concluded doesn't, so the equal protection under the law doesn't protect the right to an abortion. So in particular, it was a clause in there in the 14th Amendment in relation to the kind of the right to privacy. And right to a family life, I think, and they judged that doesn't actually create a constitutional right to an abortion. We'll have a quick look at now is the advantages and disadvantages of codification, entrenchment, and the amendment process, and these are kind of some of the key arguments that you can use in your essays. So in terms of advantages, first key advantage is that the key principles of the Constitution are protected by a difficult amendment process. So the fact that it's very difficult to amend ensures that its key principles are well protected and that ill thought out reactionary amendments fail to be passed. These key principles, which we'll look at in the next video, I think actually, include the separation of powers, checks and balances, limited government, federalism, and the protection of rights. So basic rights are codified in the Bill of Rights, which prevents legislation from threatening rights. So when amendments have major support across the population and are necessary, it can be amended, such as the 22nd Amendment. But the vast majority of the time, when there's not this major support, amendments can't be passed, and that ensures that the key principles of the Constitution are well protected. The next key next key advantage of the Constitution, nature of the Constitution, is that the rules of government and division of power between the different parts of the political system are clear. So this is particularly for the aspect that the Constitution is codified rather than the entrenchment aspect. And this covers the fact that the key rules of the US political system are codified in one relatively short document, ensures that they're easily followed, and that the US population is well informed about their political system and their rights. So the division of power between the different branches, the political system is clear, and unwritten conventions play a much less significant role in the Constitution than they do in the UK. The Constitution also protects against abuses of power within the political system. So because the rules of government are very clear, and the limitations of government power are very clear, this ensures that it's clear when the government abuses power and they can be held to account. And the judiciary plays a key role in checking the power of other branches, particularly that of Congress, by striking down legislation that breaches the Constitution. This is really important in protecting federalism and the power of the states from the federal government, and from having amendments that they don't support being forced upon them, or laws that they don't support being forced upon them. So the fact that the Constitution is entrenched and the amendment process is very difficult also protects against politicians seeking to amend it for their own benefit. And then finally, it can be argued that judicial review through and interpretive amendments allow the Constitution to be flexible, evolve, even if the constitutional amendment process, the formal amendment process, doesn't allow for it. So I argue this is a real benefit, as it allows the Constitution to change and be applied differently in a changing society and in response to changing political circumstances, even if the formal amendment process allows for little change. And this is particularly the case if you take the living constitutionalism approach to interpreting the Constitution. In terms of disadvantages, it can be argued that the Constitution is rigid, outdated, and actually fails to evolve as society does. So the fact that the Constitution is entrenched in the amendment process extremely difficult leads to it being very outdated. So the Second Amendment, for example, can be seen as ill-designed for the 21st century and makes the US out of step with other modernised democracies. Same can be said of the Electoral College, for example, and many other parts of the Constitution. The Constitution also fails to change and evolve as society does, particularly in the current highly partisan environment in which agreement on anything is near impossible, let alone supermajorities, to pass a constitutional amendment. This can be seen with the Equal Rights Amendment, which was proposed by Congress with supermajorities and had majority support from across the population in the 70s and still does today, but has failed to reach the 3/4 of states needs to amend the Constitution. It's only just, and that's why it hasn't been passed. So it shows the kind of lack of ability to change. Also, it can be questioned whether the Constitution actually does effectively protect abuses of the political system. So on the one hand, it does, but on the other hand, the fact that it's so rigid and codified and entrenched facilitates some other abuses of the political system. For example, in Citizens United versus FEC, the First Amendment was used to justify rich individuals being able to donate huge amounts of money to political campaigns, and it's a real big problem in US politics. The dominance of campaign finance and the amount of money that's spent during elections, and it was there were bipartisan attempts by Congress. We'll look at those in way more detail in a future video, and the kind of McCain-Feingold reforms to limit campaign finance and therefore improve democracy, but it was unable to do so because of the First Amendment. So it can be argued that in that regard, the Constitution kind of maintains quite an anti-democratic, abusive part of the Constitution. It can also be argued that the Constitution doesn't adequately protect rights. So the Second Amendment definitely protects the right to own a gun, but it's facilitated mass loss of life in school shootings, so it can be kind of seen as infringing on the right to life. Another couple of key disadvantages. First is the amendment process can be seen as democratic. So the fact that you need a supermajority allows a small majority in Congress or the states to block amendment proposals that have majority support in Congress and across the population. So on the one hand, that can be seen as good because it prevents tyranny of the majority. But on the other hand, you have a majority support for a change, and it's not introduced because a small minority, can block it. And the final one is that it can be argued that unelected Supreme Court judges are given far too much power in the Constitution, particularly because of interpretive amendments, which naturally grow out of the fact that it's very difficult to formally amend the Constitution. So the Constitution and the codified and entrenched nature of the Constitution gives unelected Supreme Court judges an excessive amount of power. So it's the Supreme Court's job to implement the Constitution and interpret it how they wish, and that allows them to make huge changes to political life and to the Constitution through changing its interpretation. For example, in relation to abortion, as we looked at earlier in the video. This is especially problematic as the Supreme Court is ultimately politicised, therefore calling into question its ability to interpret the Constitution and prevent abuses of power by implementing it. So the final part of the video we're going to have a look at is the blend of specificity and vagueness in the Constitution. So firstly, how does the Constitution do this? On the one hand, it's very specific. So in terms of the enumerated powers, key parts of the Constitution explicitly and specifically set out the powers of different branches. These are known as enumerated powers. So for example, Article 1, Section 8 of the Constitution sets out a number of specific powers held by Congress, including the power to coin money, establish post offices, and raise and support armies. The 10th Amendment also sets out that any powers not delegated by the Constitution are reserved to the states. But on the other hand, there's key elements of vagueness. So many of the powers exercised by the federal government and Congress aren't explicitly mentioned in the Constitution. Instead, they've been implied from the enumerators, so the written down powers that are mentioned. So for example, Congress has the enumerated power to provide for the common defence and general welfare of the United States, from which it is implied that it can collect taxes to provide for defence, even though this isn't specifically set out. The majority of the implied powers in the Constitution come from the necessary and proper, or what's also known as the elastic clause, which is the final clause of Article 1, Section 8 of the Constitution. And this clause states that Congress can make all laws necessary and proper to carry out the execution of the enumerated powers of Congress or the federal government. And in the 1816 McCulloch v. Maryland case, the Supreme Court ruled that this clause granted Congress implied powers along with these written down powers. So a lot of the key kind of implied powers that are gained by the federal government, by Congress in particular, have come through this clause. So the Commerce Clause is also really, really important. So it's not just a necessary and proper clause. So the Commerce Clause in Article 1, Section 8, so the same section of the Constitution, gives Congress the power to regulate commerce with foreign nations and among the several states. In the majority of the 20th century, this was interpreted by the Supreme Court as giving Congress broad regulatory power over the United States, as well as a range of other implied powers. So effectively, a lot of things were being defined as regulating commerce within the states. And as a result, Congress was able to pass a lot of laws that otherwise may have not been able to due to these implied powers. So for example, the 1964 Civil Rights Act used the Commerce Clause to end racial segregation in hotels and other accommodation. And it was justified through Congress's ability to do this because it argued that accommodation was involved in interstate commerce. And the Supreme Court upheld this in Heart of Atlanta Motel versus United States. In the United States versus Lopez in 1995, however, the Supreme Court set limits on Congress's use of Commerce Clause, likely kind of effectively for the first time, by ruling that the 1990 Gun-Free Zones Act that limited the possession of a firearm within 1,000 feet of a school was unconstitutional, as the measure had nothing to do with interstate commerce, even though Congress justified it on these grounds. So effectively, the Constitution, through the necessary and proper clause and the Commerce Clause, has effectively been stretched to allow for Congress to have more powers than was explicitly written down in the Constitution. This was seen as really important in the 20th century to allow the US kind of federal government to adapt to a changing society, adapt to modernization, and allow Congress to make a lot of really important laws. But in 1995, you see the first kind of pushback against that with United States versus Lopez. In terms of the advantages and disadvantages of the Constitution's vagueness, on the one hand, in terms of advantages, the vagueness and use of implied powers has allowed the Constitution to modernise in the 20th century without the need for the formal amendment process, which is really difficult for use. And this can be seen as necessary in the 20th century, which is modern, connected, and where a strong federal government is necessary to maintain the US status as the world's largest economy and greatest power. Implied powers allow the core principles of the Constitution to be maintained and not threatened, whilst also allowing the document to kind of be practically applied and evolve in politics. Plus, it can also be argued that the Supreme Court ensures that implied powers can be used whilst not being stretched too far, therefore protecting the authority of the states. And this can be seen in the United States versus Lopez. On the other hand, in terms of disadvantages, it can be argued that the use of implied powers allows the Constitution to develop and change significantly without the consent of the population, so without the formal amendment process. And it can be argued that the federal government today is far more powerful, in part due to this vagueness, due to these implied powers, than the founding fathers intended and envisaged. The vagueness of the Constitution has allowed the federal government to extend its power far too much, limiting the power of the states. And it can also be argued that the vagueness of the Constitution and use of implied powers give the unelected Supreme Court far too much power to interpret the Constitution and decide on the distribution of power in the US political system, rather than simply following from the text of the Constitution. So yeah, that's everything for this video. As I said at the start, the key questions kind of really you could get are specific to this video are in relation to, for example, you get a 30 marker on whether the amendment process works effectively. You could get one which kind of combines this with codification, so evaluate the entrenched and codified nature of the US Constitution has more advantages than disadvantages. And you could also get this in relation to some of the 12 markers, so examine and analyse the differences between the sources of the US and the UK constitutions, or you could look at get one on the differences between the natures of the US and UK constitutions. So yeah, I hope that video was useful. Let me know in the comment section below if you've got any questions or comments, and yeah, I'll see you in the next video.